The court, my name is Matthew Kelly on behalf of the appellants Greenspire Global and Stephen Canals individually, and I'd like to reserve 5 minutes of time, Your Honor. Thank you. So to kind of frame what we're talking about here today, the Florida Supreme Court in Globe Newspaper Company versus King has stated that, quote, defendants have a substantive legal right not to be subject to punitive damages claims and ensuing financial worth discovery until the trial court makes a determination that there is a reasonable evidentiary basis for recovery of punitive damages. So this appeal is about a fundamental issue of that substantive legal right. And that's whether a movement for punitive damages can rely on mere assertions by a pleading and affidavit of the non-moving parties or concerning the non-moving parties, mental impressions and the inner workings of their mind to warrant a claim for punitive damages under 768.7.2. The intentional misconduct section. Our position, obviously, if you read the briefs, is that the answer has to be no. This would fundamentally change the manner and character of the types of cases that we see these kind of claims if the court were to affirm this order. And it would put defendants at a disadvantage. In fact, it would obviate the express purpose of 768.7.2, which, according to the fourth district in Kraft General Foods versus Rosenblum, is to protect defendants from claims for punitive damages that intrinsically lack merit. And that's what we believe this case's claim is. Under the trial court's ruling in this case, the burden under 768.7.2 would shift to the defendants and permit pleading punitive damages in virtually any case where a plaintiff can state a claim for an intentional tort. And I've cited, Your Honors, a few cases that say that under Florida law, that is expressly not the case. But that is what the trial court has essentially ruled in this case. So I want to turn then to the requirements of 768.7.2. As Your Honors know, under that statute and Rule 1.190, the party must make a reasonable showing by evidence in the record or evidence proffered that provides a reasonable basis for recovery of punitive damages. The court in Estate of Despain versus Avante Group has said that that would typically include depositions, interrogatories, and requests for admissions that have been filed with the court. In this case, SGG, the appellee, seeks punitive damages for intentional misconduct. And also in this case, there were no depositions, interrogatories, or requests for admissions proffered. They proffered only the second amended complaint and the affidavit of the plaintiff's principal. And that's it. That's everything that was provided to the trial court. So we're looking at the definition of intentional misconduct, because that's important, because that's the crux of our whole issue here, our appellate issue, is what that definition requires. And intentional misconduct under the statute means that the defendant had actual knowledge of the wrongfulness of the conduct and the high probability that injury or damage to the claimant would result, and despite that knowledge, intentionally pursued that course of conduct resulting in injury or damages. Under that definition, there's three elements of scienter. There's three elements of intentionality or wrongfulness that have to be not only proven at trial, but in order to get an amendment to plead punitive damages, the movement has to show that there's a reasonable evidentiary basis for those elements. And those would be actual knowledge of the wrongfulness of the conduct, actual knowledge of high probability that injury or damage to the claimant would result, and that, of course, they intentionally pursued that course of conduct. Those are the three elements that would have to be shown, that a reasonable basis would have to be established for in order to be given leave to amend to plead punitive damages. In this case, none of those were established.
Would you agree, Mr. Kelly, that to some degree, and depends on the facts of each case, but to some degree, does the presence of one sort of lead to the presence of the others, almost like a res ipsa situation? So like in this case, if, and I'm speaking, assuming the truth of the allegation by the plaintiff here, if your client intentionally misled about these products being green and so forth, wouldn't that then lead to the other elements? Kind of, that if you sell somebody this product and it's not going to satisfy, administrative regulations and so forth, I mean, they kind of, one thing leads to the other kind of automatically, does it not?
I think it could. I think it would depend on the facts of the case. I mean, I think in this case, we don't have any record evidence or any proffered evidence of any of that. I mean, a product can contain an ingredient and a party could be unaware of it. There's other reasons. I mean, what this
perhaps, and you know, and I'm just again assuming the truth of the allegation. So you're in a pretty regulated industry and so forth, and you're sold a product that the seller knows doesn't meet the regulatory requirements. Pretty much, you know, that's going to cause the buyer harm. That's going to, you know, et cetera. It's going to kind of be like dominoes.
Yeah, I mean, I think then under those facts, I mean, you would have stated a claim for perhaps, some of the claims that were alleged in this case. I don't know necessarily that would result in the type of case that would warrant punitive damages. And the reason I say that is because, and I've cited a few opinions for your honors that say that punitive damages are not automatic in those kind of cases. But even beyond that, I mean, there has to be some reasonable evidentiary showing that the party knew that when these representations were being made that they were false. And that's the part here that we're missing in this case, because all we have, or all the trial court had to go off of for that, is simply the assertions of the plaintiff in an affidavit that verified a second amended complaint. I mean, that's it.
But now you're getting to another aspect of this case, which is not the nature of the allegations themselves, but whether there's an appropriate record evidence or proffer of evidence.
Yes, I am, and I'm kind of
yeah, I get it. Kind of all mushes together, but yeah, I get it. Yeah,
it's no, but you're exactly right. That does get to the other issue. I mean, so as I said, there was no other record evidence proffered in this case. The proffer is contained in the motion in its entirety, and it's 16 paragraphs, as Appelli pointed out in the response. All 16 paragraphs quote from the second amended complaint or the affidavit, and it's I'll point out the affidavit was filed a few years prior to this motion during the jurisdictional phase of this case. This case has been going on for quite some time. So if there was record evidence to proffer on this point, there's no doubt that the plaintiff would have done it. But they didn't. They simply proffered the second amended complaint and the older affidavit. Only 2 of the paragraphs in the proffer are actually from the affidavit. The rest of them are just quoting from the second amended complaint. Now, the affidavit did purport to verify that. But again, these are just allegations. And what we're talking about they're not just factual allegations. He's asserting what the defendant, what Greenspire was thinking when these other factual allegations that they're making were made. And that's really the problem, because there's nothing at all to support that in the record. And as I said, if you were to allow that to happen, pretty much any case then, when there's an intentional tort, you would be able to do that, because if you can in good faith state a claim for an intentional tort, then undoubtedly you can verify that your own belief as the plaintiff that they intentionally misled you, that they committed fraud, that they knew what they were doing. You could very easily make those allegations, because that's why you're bringing the claim. And so if you could state that claim, then you can get punitive damages. That's the heart of this matter here, because that's what the trial court has ruled.
Now, the plaintiff has pointed out that some of these, elements, knowledge, mens rea, if you will, can be shown by circumstantial evidence. So in one of the circumstances they've alleged is that your client changed the labels on the products, put a label over the one that the manufacturer or the creator of the product had put on there, and those labels showed different ingredients.
Yeah.
And whatever the problems there are with the affiant's knowledge in this case, it seems to me that's could be within his knowledge, because they received products with your client's label, and they received products from the manufacturer with the original labels, and they could see the difference. So would that be circumstantial evidence of your client's guilty knowledge?
I think you could make a case for circumstantial evidence, or that could theoretically be sufficient, not the proffer here, but just talking generally, that circumstantially It could be somewhat established. But I don't think that's been done here. I mean, I don't think enough has been done, because again, the facts that Your Honor just went over, these are just allegations from the complaint. That's all
Well-
that's been proffered. So, I mean, if they, and there's been.
Well,
years of
but you do have an affiant who was aware of at least the product labels, correct?
He asserts that he has knowledge of them, but again.
That's what affidavits do.
Yeah, yes. But
Right.
in the proffer, I'll point out again that in the proffer, only 2 of the paragraphs that are proffered are actually from the affidavit.
Yeah.
And the rest
Yeah.
of them are from the second amended complaint. And it's that record that the court has permitted, has obviated the substantive legal right of the defendant and allowed them to assert a claim for punitive damages. When again, I point out this case was filed in 2018. There's years of discovery, there were depositions, interrogatories, requests for production. None of that was proffered in this case. Okay, and I would proffer myself to the judges. That's because it doesn't support that. So the question is then, do you allow a plaintiff to go back to the initial pleading and an affidavit filed from years earlier to assert a claim for punitive damages in a case where really it does not belong? And that's what's happened here. Now there is another issue that I addressed, and again, the standard review is de novo, and the whole proffer, all 16 paragraphs of it, is before your honors. But I think it's an issue worth mentioning is that when I read the trial court's order, it's clear to me that the trial court considered the absence of countervailing evidence, and as we know, the estate of Despain case and others say that we can't submit countervailing evidence to the court in consideration of a motion for punitive damages. So we didn't. All of this in this case is disputed, all of it. And it was disputed by affidavit during that same jurisdictional phase where the affidavit at issue was raised. In 2 places in the court's order, it makes reference to the lack of countervailing evidence. And I know that the appellee has somewhat, I guess, of a differing view of why the judge included this, but again, it's the order is before your honors, and you can read it. But it's clear to me when the trial court says that it should be noted that there were no countervailing affidavits or evidence in opposition here, no specific denial of Mr. Cassidy's claims, and that's referring to the affidavit. Clearly, then that's being considered.
Hey, Mr. Kelly, you are into the rebuttal time you wanted, and use your minutes as you please.
So I'll just get straight to the bottom line here is the plaintiff asserted we're talking about the mental impressions and the workings of the defendant's mind, and the only thing that was proffered in this case to the court was the plaintiff's allegation of what that is. And I'll direct you to the proffer, paragraph 2 from the motion, and this is all we have to support this motion. For punitive damages, Greenspire, acting through Canals, intentionally made false and misleading statements regarding whether Greenspire's products were exempt from federal regulations. And that's it. That's the whole proffer on that element that was submitted to this trial court. So I'll reserve the remainder of my time if there's any remaining.
You about have 4 minutes. So.
Okay. Thank you.
All right, Mr. Norton.
Thank you, Your Honors. Hunter Norton on behalf of the plaintiff appellee, Sarasota Green Group. So the court is aware of what this case is about. But what is, and I want to talk about obviously what it's about, but I also want to talk about what it's not about. What it's not about is a bare bones, 6-paragraph fraud allegation where we're alleging there's an allegation of a fraudulent statement, you misrepresented the products and therefore we were damaged and therefore, that's it. No, there are 47 preliminary paragraphs incorporated into that second amended complaint.
Well, Mr. Norton, let me tell you something that bothers me in this case is, you've alleged a lot of stuff and you've got an affidavit by someone who couldn't possibly know some of these things firsthand. And the affidavit is, the statements in the complaint are correct to the best of my personal knowledge, information, and belief. Well, he couldn't testify at trial and prove a fact just by saying, I think that's true. You know what I'm saying? And so I have a concern whether this is actually a proffer of evidence versus something we hope to prove. And I'll give you an example. I want to prove that my assistant was late. All right. And I wouldn't say to the judge, we're going to prove my assistant was late. And that's a proffer. What I would say is, Judge, we have the time stamps showing when she entered the building and they show she was late. That to me would be a proper without having to actually present them to the judge.
Yeah, and that's the reason there's a distinction between the verified complaint that was verified by the affidavit and the actual proffer that we put into the motion, the 16 separate paragraphs, where we delineate, and they are attached, by the way, as exhibits to our complaint. They're in the record at 103 to 148. All of the different labels that were presented to us, showing that these were completely FIFRA exempt products, green products. And then we also attach and proffer to the court the pesticide violation notice that was issued by the state of California saying, no, these products that you're sending us are not exempt from the obligations of FIFRA because they contain chelating agents and polysorbate, which does not exempt it. So the proffer to the court was, hey, you're telling us and giving us these labels that you're having manufactured. The proffer is you're then taking those labels and changing them, okay? And then when we take over, when we get the license agreement and we begin manufacturing based on what you're told, and we don't engage in that fraudulent scheme, right? We don't replace the labels and we send the same products out to California, we get violated. And the judge even noted in his order that it was significant to him that it's not the appellants who came to us to notify us of the violation notice. No, we learned about this from a third party. So that speaks to that scienter that they are entering, that was mentioned, that they were engaged in this fraudulent scheme. And in the case that counsel relied on, in the Desposita case itself, the court states that a proffer is merely a representation of what evidence the defendant proposes to present and is not actual evidence. That was all before the court. This scheme of fraudulently representing to us that these were green products, the scheme of mislabeling the products, okay, to cover up the actual ingredients. And then when we enter in reliance on all of this, we enter into the agreement, we begin manufacturing the products with the actual ingredients listed from our manufacturer, and then discover that the switch has been pulled on us and that these are not green products based on the violation notice that we received from the state of California. That is a quintessential fraud case. It is the quintessential proffer of the evidence showing the fraud. So it's not just, hey, we allege anything else that the defendants here had this knowledge and were engaged in the fraud. It's much more. In fact, the record, like I said, 103 to 148, we list 45 pages of labels and ingredients that were misrepresented to us to prove that these were organic and green products and that they were exempt from the FIFRA. That was all proffered to the trial judge. It is dovetailed with the violation notice at 149 of the record from the state of California, showing that these labels that the appellants had placed on these quote unquote green products were in fact not green products, not exempt from FIFRA. And that is the hallmark of not only a fraud, but it's really the pinnacle, the central issue in this case. Whether or not these were, as represented to us, green products. Because if they're not green products, we're not interested in the products. Well, it was represented to us that they were green. Turns out they were not green. All of that evidence was before the court. And the trial judge, he went through in some detail everything that he had considered, all the proffers that he had received. And I must respectfully disagree with the appellant's counsel. The judge wasn't saying, I am relying on the fact that, there was no opposing evidence. There was no court reporter. So I think he was doing exactly what he was supposed to do, which was to make a record. I also respectfully disagree with the statement that the Espirito case precluded the defendants from offering any evidence. I've read that case, I don't know how many times, and I don't see that preclusion anywhere. I've handled multiple punitive damages hearings, and there's almost always some proffer of evidence in opposition or showing why what we're saying should not be considered by the court. I think the judge, certainly there's no burden to do that. You don't have to do it, but I don't think there's any preclusion on the defendants from doing that. That being said, I just don't read the order as the judge saying, I am relying on the fact that you guys didn't do this, and because you didn't submit evidence, then I'm going to just by default fine for the plaintiffs and grant the motion to assert punitive damages. It's actually very different. The court goes through painstaking detail of noting the legal standard that it is the plaintiff's burden of proffering sufficient evidence at that hearing, which would otherwise give the court a reasonable basis, the trier of fact, a reasonable basis to conclude that an intentional tort had been committed and that it justifies the imposition of punitive damages. You know, taking the appellant's position all the way through, they're essentially, you know, and it is set out in their initial brief, so I think even though it wasn't focused on in the argument here today, I think we do need to look at this. They're essentially saying there's nothing here that would ever give rise to a claim for punitive damages. And I'm mystified by that because this is the quintessential punitive damages case, where we are not only relying on your statements as to what these products are, but you're actually engaged in a scheme, if you believe our side of our proffer, to mislabel and induce us to hold these products, look at them, verify what the label says, that they're FIFRA compliant. And then when we enter into that license agreement, we begin manufacturing the labels ourselves using the same manufacturer. When we get the products from that same manufacturer, we see a different label, you know, after being notified of the California pesticide violation notice, we see a different label. And then that leads itself to the realization that what we were being shown was not what the product actually was. That is the quintessential fraud and the quintessential punitive damages case. The judge took all that into consideration, and to quote the trial judge, he didn't view this as even close. And I agree. I don't know how this could be close, because if this doesn't speak to what a punitive damages case is, I don't know what else would. Again, I respectfully disagree that we were somehow obligated to, you know, put in depositions, to put in anything beyond what we did. We submitted not only the sworn allegations of the complaint, but also all of the product data that we had, the pesticide violation notice, set out in detail in Mr. Cassidy's affidavit exactly what transpired that constituted the intentional act. This was all before the trial court. The trial judge considered it all, and I believe the trial judge correctly ruled that we were entitled to assert a claim for punitive damages based not only on the pleadings, the affidavit verifying the pleadings, but also the proffered evidence, which included, as I mentioned before, the mislabeled products, the labels themselves, and the pesticide violation notice. So unless the court has additional questions for me, I will rest on my papers and ask the court to affirm the trial judge.
Thank you, Mr. Norton. Mr. Kelly?
Thank you, Your Honor. What Mr. Norton talked about a moment ago in terms of the proffer, we're talking about the Second Amendment complaint, and there's attachments to it, but it's the Second Amendment complaint. These are allegations. And, you know, we do make an argument in the brief as an alternative argument that this is not a case that would warrant punitive damages, but we don't even have to get to that issue, because the problem is that they're still relying on just the allegations. And, you know, to illustrate that, I want to point to the judge's order where he's quoting some of the proffer, which again is from the Second Amendment complaint. And then the trial judge says, again, to corroborate these allegations. So he's corroborating these allegations. Mr. Cassidy, which is the principal of the plaintiff, stated that Knaus intentionally made false and misleading statements regarding whether Greenspire's products were exempt from federal regulation. And again, you know, to your point you made before, Your Honor, he can't possibly know that. He's reading the defendant's mind and saying, go ahead, do you have a question?
Right, yeah, well, I was going to say, but, you know, the law recognizes that, you know, your people are, it's very unlikely that, you know, your principals are going to come in and say, yeah, I knew that and did it anyway. You know, the law recognizes the need and validity of circumstantial evidence on these kinds of issues.
That could be correct, Your Honor, but in this case, there's so many of those. There's nothing to corroborate any aspect of intentionality other than what the plaintiff is asserting. And again, to illustrate that, and Mr. Norton was talking about this notice violation. And if we look at the proffer that was made in paragraph 11, talking about the violation notice, Greenspire intentionally failed to tell SGG about the violation notice. Well, where's the evidence? Where's the proffer of evidence that Greenspire knew about the violation notice? Because if we were permitted to give countervailing evidence, we would proffer and show that he didn't know. And that's the problem with allowing this amendment. They could very easily make that showing by evidence in the record if they had it, but they can't. And so they should not be able to then assert it, just assert it, and then be able to plead punitive damages based on that. And a reversal here does not preclude them from going and getting some of this evidence. If it's there, we contend it's not, and making the motion again. But to allow them to make it on this record would be to allow this type of amendment in all of these types of cases, which courts have said is not the case. So again, he can't have knowledge of some of these things he's asserting. Now, you could make an argument for circumstantial evidence, but there's a gap that's missing. They don't have enough to show even reasonably, or even a reasonable basis that anything was done intentionally, and that's exactly what they would need to show to plead punitive damages. And I know I'm probably running out of time, but I would direct the court's attention to the Bisline case, where the courts talk about, and in many other cases, that it has to go beyond even just an intentional act. So, and it's not based on just the allegations of an intentional act. So, the court said it's not a close call. I respectfully disagree with the trial court. Or do agree in some sense. I don't think it's a close call, but it's in the other direction, because there's nothing here that we're so far removed from what would need to be shown to plead punitive damages with the high bar that it is under Florida law and the substantive right that it deals with, that if it were allowed in this case, then it's going to be allowed in many, many more cases than I think courts would like to see. So we are asking that the court reverse it, reverse the order, and allow the plaintiffs, in the future, they can come back if they have the evidence. This case has been going on since 2018. If they have the evidence to show the court that they have a reasonable basis to assert this claim, then let them do it by evidence, not by allegation of the plaintiff. That should not be permitted. So once again, to sum up, we're asking that the court reverse the trial court order for reasons argued and the reasons stated in the initial brief and reply brief.
Thank you, Mr. Kelly. Thank you both very much.
Thanks, Your Honor.
In order to leave our virtual courtroom, you click the button on the screen called leave, and you